Morning, everyone. I would say the general counsel role has its challenges because lawyers being personalities, keeping 200 lawyers out of trouble has certainly got its challenges. Sometimes the construction law aspect of what I do is easier, surprisingly enough. This program is focused on being legally prepared. I'm going to focus on issues affecting claims for latent defects. These are the hidden items that arise years after the fact, sometimes years after the fact, sometimes not, but certainly after the project is complete. While my comments are largely focused from the angle of whether the owner has a claim, depending upon which hat you're wearing, you can look at it from a defensive or an offensive point of view. Just so I get an idea of the room, how many people here work for engineering firms and architects and contractors? So we have a really good mix. So you'll get this applies in all those contexts. So you'll get it. Let me review an interesting quote from President Herbert Hoover. This was obviously some time ago. And I think what he has to say applies equally to architects. But engineering is a great profession. There is the fascination of watching a figment of the imagination emerge through the aid of science to a plan on paper. Then it moves to realization in stone or metal or energy. Then it brings jobs and homes to men. Then it elevates the standards of living and adds to the comforts of life. That is the engineer's high privilege. The great liability of the engineer compared to men of other professions is that his works are out in the open where all can see them. His acts, step by step, are in hard substance. He cannot bury his mistakes in the grave like the doctors. He cannot argue them into thin air or blame the judge like the lawyers. Have you ever blamed the judge?
Absolutely.
That's
my legal strategy.
That's what lawyers never lose a case. It's just the judge was wrong. He cannot, like the politicians, screen his shortcomings by blaming his opponents and hope the people will forget. The engineer simply cannot deny he did it. If his works do not work, he is damned. Well, that might be a bit of an overstatement. So we're going to look at whether the engineer of a failed project or the architect, or for that matter the contractor, it really is damned. We'll have to see. Where did I put this little device here? So the question you have to ask yourself in every case is, does the owner have a remedy? Because you're after the fact the building's built, presumably the contractor's been paid, the architect's been paid, the engineer's been paid, the owner's the one with the problem. Does he have a remedy? Just this, by the way, is a picture of the Tacoma Narrows Bridge collapse, which occurred in November 1940. It's a classic case of the engineers of a glitzy new bridge, it's a suspension bridge, failing to provide sufficient stiffening to deflect wind loads. They made some errors in calculation. A steady 42-mile-an-hour wind caused resonant vibration to start the bridge swaying in a torsional way. The ultimate collapse was spectacular. The bridge lasted only 4 months, so many of the limitation period type issues we're going to look at probably wouldn't have been relevant. But if you go online and Google it, you'll see there are actually old videos of that bridge collapsing. There's a guy in a car at one point who's in the middle of the bridge and the thing's swaying, and he's trying to run back and forth across the bridge without falling over the edge. It's quite fascinating.
Apparently he's trying to rescue a dog.
Oh, is that right?
Car. I don't know if that's a myth, but apparently there was a dog in the car. So he was most
I don't think anybody died, actually. The car certainly fell in the river. You can see that in the... So what are the issues that arise with respect to latent defects? We're going to look at these issues. Statutory limitation periods. What are they? How can you determine if the limitation period has expired? Second thing, contractual limitation periods. How do contracts attempt to time limit claims? What should you be looking for when you look at a contract? Nextly, who can be sued? There's many players in the construction industry. Which ones can be sued? Do you need a contractual relationship? And if you don't have a contractual relationship, what conditions govern your right to sue? Next one is insurance, which is a big issue. Is there likely to be a pocket available? Remember, you're years after the fact, so some of the players may not even still be in business. What kind of policies are available to provide coverage? And the last one is, what's the best practices in terms of collection of evidence? So first, we're going to start to look at limitation periods. Prior to January 1st, 2004, there were a hodgepodge of limitation periods in effect in Ontario. Let's deal with Ontario for the time being, and it's sort of set the tone, and the rest of the provinces have pretty much followed. Generally, the period which came up in construction cases was 6 years for contracts and tort claims, and that 6 years was subject to a bunch of common law rulings on when the 6 years started to run, and the 6 years was considered to run generally in terms of when it could be said the plaintiff discovered the claim. That led to claims being brought 20, 30, 40 years after the fact, because obviously if something went wrong in the building and no one perceived it before, then the claim wasn't discovered. I, for instance, acted on a number of claims in the late 90s relating to building envelope problems where the buildings had been built in the 70s, early 70s in some cases. At a point in time, the government came to considering amending the Limitations Act in Ontario and to organize the limitation periods. There were a whole bunch of them that were quite confusing, even for lawyers. We used to have these binders, and you'd look up the subject matter of what the claim was and look at all the potential limitation periods. They were all in different statutes. And the government had heard loud and clear that that was unacceptable. It was catching people unawares. So they were going to amend the act, and they were subject to pretty intense lobbying from the construction industry that they wanted to sort of be free and clear of the potential for never-ending liability. So we'll look at what they did, but as of January 1st, 2004, the limitation period was made, the basic limitation period, we'll call it basic because there's another one. Basic limitation period now is 2 years from the date of discovery. So what does discovery mean? Discovery is the day on which a reasonable person with the abilities and circumstances of the claimant would have had knowledge of 4 things. The first is the injury, loss, or damage. That's obviously the most obvious, that something went wrong. The next is that that was caused or contributed to by an act or omission. In other words, it has to be an identifiable cause. The next is that that act or omission was that of the defendant. So you have to know who was involved. And the last one is that a proceeding is the appropriate means of remedying it. So a potential plaintiff has a problem, has to be able to identify who they're going to sue, has to be able to understand that there has been damage occurred, and has to know that the person that they can identify was the cause of that problem. The test is stated in an interesting way when they say a reasonable person with the abilities and circumstances of the claimant. It's not exactly applied to the person who has the claim. It's applied to a reasonable person in the same circumstances. That's because you have an obligation of inquiry. You can't close your eyes to a problem and then turn around and say, oh, I never discovered it because it just didn't turn my mind to it. Well, if there's a problem, you have to do what a reasonable person would do to react to that problem. Being willfully blind is not a way of extending the limitation period, in other words. So the question is, when would this sort of half objective, half subjective person be aware of the 4 things that are up there that would cause identify the cause of action? Let me give you an example. I had a case in, I think it was about the early 90s, where some people came to see me who had sold a house in a divorce proceeding, and they were being sued. And they were being sued because the purchaser of the house found that the house was completely full of urea-formaldehyde. And the allegation in the statement of claim was that it was obvious that the house was filled with, my client said, we don't even know what UFI is, and, but the allegation in the claim was that it was obvious to anybody that it had UFI in it, because as you looked, if you look closely in the bricks on the outside of the building, there were little plugs in the middle of the masonry where they had drilled holes to put the injector in to shoot this stuff in. And in the garage in particular, I saw the pictures, there were little white plastic plugs all the way along the drywall in the garage where they did the same thing. And the allegation was, and I remember seeing my clients examined in discovery on it, the lawyer tried to suggest, well, you saw the white plugs, it's obvious it's UFI. And my clients had no idea. They'd never heard of UFI before. They just lived in another sphere completely. And it was an interesting question then as to whether, if this test had been applicable, whether a reasonable person in the same circumstances, their circumstances were they had no knowledge of construction, neither of them were handyman type people. Anyway, in the end, just to put an ending to the story, the plaintiffs agreed to let my clients out of the action and proceeded against the real estate agents who really were the ones who should have had the knowledge and should have recognized the issue. But it gives you some context for kind of considering that issue, what a reasonable person would know.
So ignorance can be a defense.
Ignorance can be a defense if you know, in their case, they had no reason to make any inquiries. They just sold the house. So here's another one. I just pulled this picture up, but you can see in this picture the supporting joist in the home was short and it failed to span across the vertical beam, so the builder just sort of jury-rigged it. Assume that that's clearly visible in the basement and would have been seen by anybody wandering down there. Now, I think I would have recognized that. I'm no handyman myself, but I know a couple of things, and that seems sort of obvious to me. But I'm not sure most people buying a house would recognize that. You know, if the claimant was a home inspector, obviously, but they would have the knowledge. If it's, you know, my mother-in-law, I don't think so. And you'd have the same problem with leaking around a window, which is common in building envelope problems, where the first sign of water problems in the building envelope comes out typically around the interfaces, windows being one of them. And some people are leaking. I'm just going to put more caulking on it. And whereas, you know, someone who's an expert would look at it and want to know a little bit more about why that's happening. So I said there was another limitation period. There's the basic period of 2 years from discovery. That doesn't address the concern that the construction industry had to put an end date to it. And so they came in with what they call the absolute limitation period, and in Ontario it's 15 years. That 15 years runs not from discovery, but from the day the act or omission took place. So that is the end date. That kind of defines when you can breathe easy. There are some exceptions, most of which don't apply in a construction context. It doesn't run against minors. It doesn't run against people with mental disabilities. It doesn't run, this one could apply if there's willful concealment of the condition. In other words, if you have a leaky basement and you plaster over the wall or do something to it in such a way to hide the condition. The important one for construction purposes is environmental claims. In the environmental context, it doesn't run at all against a claim that hasn't been discovered. So environmental claims just continue. I assume there was a policy reason for that. Before you go away with the idea that after 15 years you're totally free and clear, there's this case YCC 382, York Condominium Corporation 382, where they had to consider the transition provisions of the Act. Remember I said that previously there was a 6-year period, and they brought in a new rule on January 1st, effective January 1st, 2004. Basically, the general transition provision is that if a claim is discovered prior to January 1st, 2004, you're under the old regime. You're subject to the 6-year claim. If the claim was discovered afterwards, you were subject to the new regime. But with respect to the 15-year ultimate limitation period, the Act really wasn't very clear. And so the courts ruled that the 15-year period does not start when the act or omission occurred, but rather starts on January 1st, 2004 if for claims that are discovered after that point. So if the claim existed or if the act or omission occurred before January 1st, 2004, but was discovered afterwards, they moved the start date up to January 1st, 2004. That means that the actual date for those claims is the drop dead date isn't 15 years, but it's January 1st, 2019. So if you've built a building and you have some concern about it, you have to keep holding your breath till January 1st, 2019. One other thing in the Limitations Act, claims for contribution and indemnity. These are claims where someone has claimed against you and you want to blame someone else and claim against them. That's very common in construction. The owner sues the general, and the general then turns around and third parties the subcontractor, then third parties the subcontractor, and so on. Or somebody drags in the architect or engineer. Those claims are subject to a separate limitation period. If you are sued and want to claim against someone else, you have 2 years to bring that claim from when you were served with the claim. It can lead to some weird situations where the plaintiff no longer has rights to sue a particular party, so it sues everyone else, and then they drag in that party to the action, so there's no claim between the plaintiff and that party, but everybody else has dragged them in. Before I leave limitation periods, there's a couple other things you should know. What if parties are negotiating and don't really want to sue, but also don't want to lose their rights to do so? Under the Act, limitation periods can be suspended by an agreement in writing or an agreement to mediate a dispute with a formal mediation agreement. So you can agree, lawyers refer to it as tolling the limitation period. You can have an agreement to set aside the 2 years, continue talking, and then you usually in these agreements you'd have a drop dead date, or you'd have a notice provision that says that as of giving notice the period starts to run and you have 90 days afterwards or something like that. But note that those agreements, that right to suspend the limitation period only applies in a business context. For any transactions that would be governed by the Consumer Protection Act, in other words consumer transactions, the 2-year period cannot be varied. And that's to keep parties with strong negotiating power, business parties, from foisting different periods upon consumers. In the world of construction, it would be, and generally it's a shorter period that they try to do. We'll look at that in a second with contractual limitation periods, but to keep people from having standard form contracts with consumers that provide for short limitation periods, the Act doesn't allow that.
And I think we have a question.
Yep.
Okay.
I'm curious to know, does a contract term affect the limitation period if you have a long-term contract? Like if you had a 10 or 20-year contract, I'm thinking of some of the P3 contracts now, how those limitation periods apply within the term of the contract.
That's a very good question. It kind of depends upon the nature of the claim. If you're talking about, let's say you have a claim for an extra and the contract is a long-term contract, and so if there's a final date for final payment, I think it runs from then. The question is, when's the money due? There's a whole provision about, banks have the same issue on promissory notes, for instance. Is it a demand promissory note, or does it just continue infinitely? Is there a limitation period on it? If you look to see when the payment would be due, if it's not due, then there's no claim. In order to protect that issue, though, because people are still a little bit unclear about that, there have been agreements to basically agree that the limitation period doesn't apply until, or you're not going to discuss it until a certain date in the future, often the end of the contract. That's typically the way it's been handled, and often the contract will say that. If you, in a minute, we're going to look at contractual limitation periods, but you can override all this in a business context with contractual provisions. So the contract will often contain its own limitation period, essentially the period by which you must assert a claim, and in that case you would use that, not the statutory provisions. Before we jump to contractual limitation periods, let's just, on the statutory front, are there any questions about the 2 years and the 15 years? Yep.
If the defect was created in 1932 and discovered in 2005, I would have until 2020 to sort of it.
You would have, if it was discovered, when did you say it was discovered?
2005.
Yeah, you would have, if it was 1932 and discovered in 2005, you would have until January 1st, 2019 to start a claim. That would be the date of expiry of the 15-year absolute limitation period. Oh, sorry, no. If it was discovered in what day? 2005, you'd have till 2007. The question, because you'd have 2 years from the date of discovery under the 2-year rule. The 15 years only applies where the date of discovery is long after the 2 years. Right? In that case, you've discovered the problem in 2005. The Limitation Act kicks in and says you have 2 years now to commence your claim. Yeah. The better example for what you're trying to point out is if the error was 1932 and it was discovered in 2017, what happens? Because somebody might say, well, wait a minute here, it's been 15 years since 2004 or whenever, and why doesn't the 15 years kick in at some point? Because it's 1932. And that case I pointed you to says the limitation period for the 15-year period starts to run January 1st, 2004, so it would be 2019 would be the expiry. So then you'd have time, you'd have to commence it in 2018, for instance.
Didn't you say that the ultimate limitation period is 15 years from the act or omission time of discovery, like if it was 1932?
It is, but that's why the transition rule sort of was complicated, because they changed the courts are very conscious of you can't change the rules midstream. So the 1932 claim that you have is under the 6-year rule that existed prior to the change of the law. As of 2003, for instance, that person still hadn't lost their rights. So just because somebody passed a law in 2004, they didn't want to take away that right. They wanted still the 15 years to apply to it. And that's how they did it, basically. Yes?
Just continuing on the same question. So 2004 starts the 15-year for the discovery, 2019.
For claims that were before that but not known.
Now, let's say it's discovered in 2018. So then it would be 2 years from that time to file the claim, then, right? 2020.
Except that the 15 years would have expired as of January 1st, 2019.
So if it's discovered in 2018, then,
Yeah.
1 year before that. So the 2 years would take in from that time to file the claim?
No, but it would, but the 15 years overrides the 2 years in that case. That's the reason, that's the way the 15-year period works. It will override the 2 years if it's at the end of the period. Now that we're all thoroughly confused. Yeah. The reality is, apart from that case, I actually haven't seen one of those. So, and we're shortly going to be in a position where there won't be any more of those. So, hopefully, we won't have that problem.
Unless there's willful concealment.
Yeah, unless there's willful concealment, actually, and then the 15 years doesn't even run. Although it'd be pretty hard to willfully conceal something for you
At least
know,
not
80
since
years.
1932.
Yeah.
King Kong climbing the Empire State Building.
Kind of jump here to another to the slide 9 there. Let's talk about contractual limitations period. So rather than be governed by the Act, you can just agree to have your commercial dealings governed by other time periods, and you see this virtually in all construction contracts nowadays. I'll say this, as a general matter, the period has to be clear or the judge will find the provision to be unenforceable, and then it defaults back to the statutory period. So let's look at the, just as an example really, the CCDC 2008 contract, see how it deals with the issue. Sections 12.2.1 and 12.2.3 are the place to start, which is why I jumped to this slide, just does it in a more coherent fashion. The first thing to notice is that all claims in the contract, except those that are specified, are deemed to be waived by the parties. So the way in which the CCDC works is it says all claims are waived as between the parties except for these, and then it sets out the instances where you can make a claim. We'll look at section 12.2.3, which is the owner's waiver, because that's the one that really governs with defect claims. I'm assuming the contractor's been paid by now. Claims are all waived except for the following. First one is those made in writing prior to the date of the final certificate of payment and still unsettled. Well, those aren't latent defects, so that just claims at the end of the job. Next one is those arising under the indemnity provisions of the contract by third parties. So we'll look at that in a sec, but those are claims by third parties for damages or injury or whatever. The next one is those arising under the indemnity provisions as between the parties. So just keep that in the back of your mind because it's important. Next one is those for damages where the contractor's actions result in substantial defects or deficiencies in the work, which means they are basically unfit for their purpose. Now, before you think, oh great, I can sue, there's a proviso to that. However, for those to be claimed, they must, and it's set out in section 12.2.4, have been the subject of a notice in writing within 6 years of substantial performance or such shorter period as is prescribed by the applicable limitation period statute in the jurisdiction, i.e. in Ontario that would be 2 years. But in my view, since the limitation period in Ontario does not contemplate a limitation period tied to substantial performance, it contemplates a limitation period tied to discovery. I would argue that the 6-year period actually applies, so that it says 6 years or such shorter period. There is no shorter period than 6 years that's applicable, but that has not been definitively determined yet. The next one is warranty claims, which are claims under the contract under a warranty, and there's going to be a provision that says what you have to do to assert a warranty claim. The next one is claims arising from errors or omissions after substantial performance. I suppose that could be errors and omissions for finishing work. Typically they wouldn't result in any latent defects, so that probably doesn't arise in a long-term issue. So you can bring a claim for defects after substantial performance. It appears you'd have 6 years to do so. Now let's go back to the indemnity provision that I mentioned. What about the right of indemnity? The indemnity provisions 12.1.1 sets out that the owner and the contractor's indemnity obligations, they set it out in a very confusing way because it mixes third-party claims and claims between the parties. Typically, indemnity means you're seeking contribution from someone for something, a claim somebody else is making, not a direct claim between the two parties. So that for some reason or other, the drafters of this contract, the CCDC form, confused the two concepts, but it works. It's confusing. The contractor has to indemnify the owner in respect of claims for negligence or under contract where a notice in writing is given within 6 years or within such shorter period as prescribed by the Limitations Act. And the instances where that occurs is there's a limitation to it. It says you have to indemnify, but subject to the following qualifications, and be very aware of these if you're an owner and accepting a CCDC contract, because they insert numbers without context, really. I mean, if it's a big contract, the numbers may make no sense. First is where there is insurance required under the insurance provision, the claim is limited to the amount of the insurance. So if the claim you're asserting is governed by an insurance contract that's required under the contract, the claim is limited to the amount of the insurance. The second qualification is if there's no insurance, the claim is limited to the greater of the contract price in $2 million to a limit of $20 million. So, you know, if it's a $500 million contract and you're using a CCDC form, which is probably unlikely, but there's still a limited claim of $20 million. That strikes me as a bit weird. So the third one is if a third-party claim, if it's a third-party claim for loss or injury, sickness, death, any of those things, the brick falls off the building and hits somebody in the head and kills them, and there's a claim for that, the amount of the claim is unlimited, because in that case the claim is coming from outside of the relationship between the parties, and the contract considers that to be a claim that has to be addressed to its full extent. Whoops, just a second. There was what I wanted. This case, Wood Buffalo Housing, just came out this year, and I thought it would be useful just to have a brief look at it. It's out in Alberta. Alberta? Yeah. There was a fire in 2007 in a multi-unit residential building, and notice was first given when the claim was filed in April 2009. The contract contained the CCDC type wording that a claim was waived unless notice was given within 2 years or such shorter period. The date accepted by the court for substantial performance was July 2nd, 2004. Therefore, the defendant moved to dismiss the action, arguing that the date of discovery of the claim, which was actually after the 2 years from substantial performance, did not matter because the contractual provision fixed the limitation period without regard to discovery. There's no mention in the CCDC contract of anything to do with discovery. It's based solely on time after substantial performance. The plaintiff argued that discovery should be read into the provision, that that's a fundamental concept, that you can't release a claim that you don't know about, and therefore you have to read discovery into it. The Alberta court found that it was in fact a waiver of unknown claims, that the contract contained a waiver of unknown claims, that the discovery concept was not imported into the contract, and it was not ambiguous and therefore could be enforced. Interestingly enough, that wasn't the end of the decision. The court then turned around and said that since the Alberta Limitations Act does not permit agreements to vary the limitation period, it's different than Ontario, that the provisions were invalid as inconsistent with the Limitations Act, and therefore, because they purported to shorten the limitation period over that would be applicable in the Act, because the Act would contemplate discovery, which they said was not imported into the wording. So the result was that the action was allowed to proceed. The plaintiff didn't lose its rights. And if you accept all that reasoning and it was applied in Ontario, the result would have been different, probably. Now, before we leave contracts, be aware, and we already mentioned it in terms of the CCDC, where it contains a limitation of liability, essentially that you're limited to the amount of insurance, or you're limited to a set sum of money. Be aware of these kind of provisions in contracts. They're fully enforceable. It's also a way of protecting yourself if you're a contractor and you don't want to bet the bank. You can time limit claims and you can monetarily limit claims. So, And you see that in professional contracts quite frequently now, where professionals have limited the claims that can be brought against them, sometimes to the amount of the fees charged or to some percentage of the contract price. Here's another fine piece of construction. So just ask yourself whether the stupidity of this construction is discoverable by the average person. Another question to ask yourself is, when you see something like this, was a release given? Sometimes both parties have claims at the end of a contract. The contractor has a bunch of claims and the owner has a bunch of deficiency claims, and they meet and they agree to settle this claim. The contractor might be claiming $300,000 more for extras, and the owner says he has $300,000 of deficiencies, and they can't agree. But they can agree that, okay, we'll pay you $50,000 and you go away, and the contractor says, I want a release, I don't want to be bothered by your stupid deficiencies anymore. And the owner says, okay, so they sign a release. And then years later, the roof of the building falls in, and the owner wants to sue because of some fundamental defect, and the contractor stands up and waives the release. And the release wasn't drafted in such a way to prevent any claim. It was a full and final release for everything arising out of the project. It's something to be very careful about. I once had a consultation with a municipality that had a sewer collapse. I won't go into the reasons, but it was a sewer way underground, and they wanted to sue the people who put the sewer in 15 or 20 years previously. And I asked for all the files, and I got 10 boxes of documents from the construction time, and I went through them all, found a full and final release, unlimited in terms, because there had been a dispute at the end of the job. And it kind of compromised their right to bring the claim that they had in mind. So be careful to limit the release to known items, or sometimes I've seen claims where the concern of the contractor is not to be nickel and dimed with little deficiencies after the fact, even because they say, I don't care whether you know about it, I don't want you to phone me up and tell me that the eaves trough needs fixing next year or something. So it's a full release, but it's limited to, say, claims that have a value of more than $50,000. I've seen that. So you keep the major things in play. How are we doing for time here? Okay, okay. Before we look at who can be sued, questions on contracts? You pretty much need the contract in front of you to be able to really delve into it. Yes?
Ken, quick one. What's the essence of a tolling agreement?
Typically, it says, whereas somebody has a claim, whereas somebody disputes the claim, there's no admission of liability, blah, 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 and whereas the parties want to have a discussion and attempt to resolve their differences, therefore it's agreed that the limitation period applicable to the claim is tolled commencing such and such a date, meaning it just is suspended, and it runs until such and such a date, and sometimes it says there'll be a notice provision in there to reconstitute the limitation period upon the date of the notice, and then it'll run for 90 days or whatever. There's various ways of doing it. There's a bunch of standard forms that most lawyers would have, so you can do it that way. But you know, I think actually quite an informal agreement that basically says, as long as it's in writing, it has to be in writing. That's the important point. You can't orally agree to suspend a limitation period under the Act. It has to be a written agreement. As long as it defines that the limitation period is to stop as a particular day. And that means that if there's already an issue about the expiry of the limitation period, as of the day you brought your claim, that somebody hasn't lost their right to assert that you're already out of time. You've just deferred the whole issue, because that sometimes happens.
That agreement made any time contemporaneously with the progress of the works.
Right. That's often what happens, because particularly with insurers, where they're going to do an investigation, They want to see what the experts have to say. Everybody wants to get a sense of the value. One of the problems with the 2-year limitation period, although it's much more efficient than the 6-year period in terms of getting rights out there and asserted, it often is premature. I mean, 2 years is not a long time for a major problem. You won't know what your damages are. Sandra, who's speaking this afternoon, and I had a case a couple of years ago where I had to start the action because when it came to me, there was clearly going to be a limitation argument against us made because the clients had been investigating it for a long time, and the argument would be made that they knew about the problem more than 2 years before. And so I immediately started a claim, but they hadn't even started the remedial work yet. We had no clue what it was going to cost, and as the claim proceeded, we kept amending our claim to change the amounts, and it's unfortunate, but that's the way the Act works. In that case, nobody was particularly interested in tolling it, so I had to just proceed and put my head down and go and hope that by the time I got to trial, they'd actually figured out how much this thing was going to cost so I could produce the evidence. Fortunately, we settled, but any other questions on contracts? Oh, sorry.
Okay, sorry, quick question. Did you say that under Alberta legislation, you cannot shorten the limitation period?
Yeah. You can't vary it, I believe. I don't have the statute here, but you certainly can't shorten it. I don't know whether you can lengthen it, whether...
Section 12 of the CCDC, the 6-year rule is?
Right.
Can that be reduced down to a 2-year rule on an Alberta project?
Well, no, because that's what the court in Alberta said. They said that the Act, you couldn't apply that. I mean, my argument is in that provision that because of the discovery rule that the 2 years wouldn't apply anyway. The court didn't turn their mind to that issue. They just said it would, if your argument is effective, it would purport to shorten the period. That's not allowed under Alberta, so it's an ineffective provision. Therefore, the regular limitation rules apply, which means that in that case, the plaintiff hadn't discovered the problem until a certain date and they commenced their claim within the 2-year period from the date of the discovery. So. Okay, turning to who can be sued. Obviously, there's lots of players in the construction industry. You got contractors. You could sue them in contract or tort. You got subcontractors. This is from the owner's point of view. You got a claim against them in tort because you don't have a contract with them. You got design professionals. Could be contract, could be tort. Municipalities, typically in tort. Material suppliers, also in tort. They're kind of product liability type claims. If you're relying on tort law, meaning you don't have a contract and you're claiming somebody owes you a duty of care and that they breached the standard of care and you suffered damages as a result of that, you have to be aware of a couple of issues. One is the Winnipeg Condo and Bird construction case held that those responsible for failure to take reasonable care in constructing the building will owe a duty in tort if it can be shown that the failure would create defects that pose substantial danger to the health and safety of the ultimate occupants. The issue in tort law is, does somebody actually owe you a duty of care? And who is the duty owed to? And there's a whole bunch of law about proximity and whether the relationship between the parties is of such a proximity that a duty of care is owed. And what this case has said is that in order to advance a claim in a construction context, it was a subsequent owner in that case trying to bring the claim, by the way. So it wasn't the owner who actually did the contracting. Probably, if it had been the owner who did the contracting, the court would have not found proximity to be such an issue, but it was several owners removed. And the argument is, I don't owe a duty to somebody, I don't even know who they are. I mean, they came along years after the fact. And the court said if it's an issue of health and safety, then the duty is essentially presumed to be there. Many problems would appear not to be safety related, but I've been able to argue, I think successfully, certainly enough to get insurance companies to pay up, that, that things like leakage problems in building envelopes, which cause stucco or bricks to fall off, that's a safety issue, obviously. Spalling bricks, all that kind of thing probably meet the test. So a lot of things you might not think are safety related can be argued to be. In the absence of a dangerous condition, though, you're going to have to establish that legal proximity, and sometimes it's a tough case depending upon how the relationships have been set up. Municipalities are an interesting one too. If you, I mean, what's the claim against a municipality? Well, it's usually based upon something to do with the building permit process and their review of plans. There's a case, Hilton Construction against the city of Mississauga, relating to the tower, what used to be the Hilton Tower. I forget which hotel it is now. It's changed hands a bunch of times, but it's right at the end of where you exit off the 427 to go near the airport. Right there, there's a two-building complex, and the higher tower was built by a Quebec company that. And it turned out the engineer miscalculated the shear stresses when he was designing the concrete. It's a concrete building. And Hilton realized it when they started to have drywall cracking in the rooms on different floors, and they couldn't figure out why, and they brought in experts. I think Ellis Don did the work. And they realized that the building was starting to shift. Literally, the concrete slabs were shifting. And so they had to close it and evacuate it, and then they proceeded to put in, basically build a steel building into an existing concrete structure to reinforce it by putting steel beams up. The main ballroom has the main structure, and then they put steel beams up through closets and put grouting, some kind of grouting between to link them. It was really complicated. I got a tour of it when they were doing it. It was fascinating. But they turned around, the guy who built, the company that built it didn't have any assets by the time they brought the action. And the engineer only had $1 million of insurance. So, and this was like a $10 million bit of remedial work. So they turned around looking for another pocket, and Hilton sued the city of Mississauga on the basis that the error was in the actual drawings and material that had been filed with the city of Mississauga. And you could actually, the calculations, you could actually circle the spot in the calculations where the engineer had made a mistake. And the case, I had acted for the contract that didn't have any assets until they decided they didn't have to defend the case. That's why I know a little bit about it. But the case proceeded against the city, and the case rules that that you can't expect a plans examiner to look at the calculations in that much detail. That, you know, it's a cursory review for fundamental basic things that affect the public's interest. They're not there to be a check on the engineer's complicated shear calculations. So if you're thinking of asserting a claim against the municipalities, be aware that the duty they owe you is not a very high standard. And quickly on insurance then, it's a huge area, but it's also essential for latent defect claims, because often the parties that were involved in the construction are no longer even around, or if there is a company that has the same name, it's actually a different company, a subsequent company, and it doesn't link to the past one in any legal way. So here's a listing of basic types of insurance that are available. Property insurance is triggered by an occurrence or accident. And in the case of property insurance, the governing policy is the one that is in effect at the time of the event. So that if the event that is the, which is an issue itself we'll look at in a minute, but if the event is something that happened years ago, you'll have to go back and figure out who is the insurer for that year that it happened. Professional liability insures errors and omissions. It's a claims made policy, meaning it insures the person, the policy that reacts to the claim is the one that is in effect on the date the claim is made. So lawyers, for instance, have claims made policy. If someone wants to sue me for something I did 5 years ago, it's not the policy we had in effect 5 years ago that responds, it's the one I have now. CGL policies, commercial general liability, insures for bodily injury or property damage caused by an occurrence. An occurrence is considered to be a fortuitous event or an unfortuitous event, but it's a policy in effect at the time of the incident responds. Product liability is you don't really come up against that very often on construction, but it is possible, and it's damages caused by a defective product. It's a very expensive type of insurance to have. There's also builder's risks and wrap-up policies that insure everybody on the project, and typically they contain components of CGLs and property policy and professional liability. In latent defect cases, the insurers involved are almost always professional liability for the design professionals and CGLs for the contractors involved. The CGL policy will contain an exclusion for the contractor's own work, and that's provoked a whole lot of case law about what is considered contractor's own work, and also what the damage is that relates to the own work. So if you have a leaky, in my context where I've done building envelope work, if there's an error in the work for something in the building envelope, the insurer might refuse to cover that portion of the work, the bad insulation or whatever they put in, but the leakage and the damage that's caused by that would be covered. There's also the issue of whether the policy in a CGL of a general, whether it covers or doesn't cover bad subcontractor work, and it appears to depend on the jurisdiction. Generally in Canada it's excluded if covered by the general contract, but courts have found ways of compensating owners for bad subcontractor work under these policies. You can also buy an endorsement which covers your subcontractor's work. So if you're doing a project, you may want to get legal advice as to whether you want subcontractor work insured or not. The last sort of issue that arises in insurance is what triggers the potential liability of the insurer, and when is the insurance invoked. Example, if the building was built in 1995 and the problem was discovered in 2005, which insurer is on the hook? The one which issued the policy when the defect was incorporated into the building, or the one which issued the policy in the year the problem was discovered? Or if it's a problem that occurs over time, a bit of all of them. I mean, it gets to be a complicated question. In this case, Ali Bertrand and Frere, it concerned defective concrete in a large number of residential foundations. And there are a number of different theories that were put forward to the court. Under the exposure theory, property damages are considered to have occurred from the first exposure to conditions which ultimately and inevitably would cause the damage. That would make the policy in effect on an early date, the applicable policy to speak to the loss. Under the manifestation theory, the damage occurs when it becomes known to the insured, which results in the policy in effect on the date the insured becomes aware of the loss, being responsible to speak to the loss. Under the injury in fact theory, the damage occurs when the damage occurs, whether or not anyone is aware of it or could have been aware of it. If the damage is continuous, every policy in effect while the damage occurs is responsible to respond to the loss. And under the continuous trigger or triple trigger theory, the property damage is deemed to occur from the initial exposure to the time it became manifested. And all policies in effect during that time period are to respond. So there's those four possibilities. The courts have actually not determined definitively which of these theories is the one that they're going to use. They basically said we have to look at the facts of every case and apply it for every case, which makes no sense to me whatsoever. There should be a ruling on it so we all know, but that's what they've ruled. Here's another picture for you of a typical type of water problem. You can have leaking around windows, and mold will occur, and somebody's got to do something about it. And this moves nicely into the issue of collecting evidence. It's quite problematic in a latent defect case to deal with evidence, A, due to the passage of time. You may have limited access to information from the time the problem actually arose. The files may have been destroyed. And the second reason is the evidence gathering process itself informs the consideration of the issue of discoverability under the Limitations Act. So, meaning that, you know, somebody's going to turn their mind to when the owner knew or should have known of the problem. And when does the owner know enough to say, to be able to meet those 4 requirements? Well, that can be impacted by the way in which you gather your evidence. So you obviously want to document the problem and the conditions before the problem is fixed. So you're going to need that for evidence purposes. And you also have to do so with an eye to the 2-year period. So the first thing to do is assemble everything, get all the documents you can, and put, lawyers refer to them as litigation holds, but some companies have policies on document destruction after a period of time. You want to get that policy suspended with respect to this project and have all the documents taken and put somewhere where they're not going to be lost or destroyed. You need to document, obviously interview anybody who's around who knows about the construction and the problem. You need to document the investigation carefully. You're going to need to justify what you did within the court proceedings. So you're going to need to be able to show who observed what on which day and what they observed. The advice for lawyers actually is to monitor the experts that you retain. They won't necessarily appreciate the legal framework and or the way the evidence is gathered and documented, so you're going to want to set up protocols to do that. You need to monitor the remedial work to make sure that it's all documented, because when you go to court, you're going to have to prove your damages and that what you did was reasonable, and why certain steps were taken the way they were. Often, obviously, it's more expensive to remediate something after it's built than it was to build it in the first place. The case Sandra and I had a couple of years ago related to replacing a absolutely humongous, what they call a super flat floor in a warehouse that had problems, that was cracking, and replacing this floor in a building that was fully operating with huge amounts of inventory in it and separating off the inventory. Oh, I know. The other thing was it was a type of facility that manufactured a product that required absolute perfect cleanliness. When you went in to see this, you had to put on a white lab coat and all this stuff, and because of the products they were manufacturing, there couldn't have any dust. So you can imagine the problem, them breaking the whole warehouse into units and replacing the floor and parts of it without getting any dust on anything else. So it made it quite a bit more expensive, and we had to document all that. You want to involve the defendants. Now, you can't just go and remediate and then sue without exposing yourself to attacks that the claim could have been avoided, or that you didn't go about remediating it properly, or that they had a better way of doing it. So you'll face allegations that you spoiled the evidence so that they can't look at it, and that the remedial work was unnecessary or excessive or could have been done a cheaper way. And if you're so afraid of the defendant's responses that you wish to avoid involving them in the evidence, then you better ask yourself some questions about how valid your factual position is. You're going to face their position in the claim anyway, so you might as well face it early on. And on occasion, actually, in doing this, in cases we've actually cooperated, and some of the defendants have come forward with solutions that worked pretty well. In one case, actually, we got the contractor to come in and do the work again at a big discount because they wanted to avoid the claim of having somebody else do it. Last thing to talk about is the use of experts. Depending upon the budget for a project, you may need to involve 2 experts. Amendments to the rules now require experts who report to the court as experts to sign a certificate in which they attest to their independence and impartiality. And case law typically allows access to the party's dealings with its expert to some degree to assess the degree of impartiality. It becomes an issue in cases where an expert is retained at the outset to discover what is wrong, then prescribes the remedial work, and then morphs into a litigation expert to provide evidence to the court. Often the expert which prescribes the work to remediate becomes very close to the problem and to the client and its interests, and the documentary record between them, if exposed, would challenge that expert's independence. Plus, the expert has a financial stake in having found something wrong, obviously, because he got the retainer to do the remedial work, all of which is sort of good fodder for cross-examination at trial. So this requires a lawyer, certainly in my position, to look at the circumstances, and if the budget can allow it, you really want to have an expert that you set aside for court testifying, kind of watching what's going on, but not directly involved in it for the purpose of reporting and preparing a report to the court. There wasn't a Supreme Court of Canada decision came out a couple of weeks ago on the use of experts, and they determined that in that context I just described, it wouldn't disqualify the first expert probably from testifying, because even though he could be said, or he or she could be said to have a question about their independence, it probably wouldn't go to the threshold question of whether they could be an expert before the court. The court would listen to that evidence, but the Supreme Court of Canada also said the attacks on that expert's independence or impartiality are certainly fair game, and is up to the trial judge as to how much weight to be put on it. So in a small budget case, for instance, I might very well have to use that remedial expert and just make sure that we try to manage the process in such a way that we maintain an appearance of independence as much as we can. So that's everything I have to say. I think we have like 1 minute on my watch, or a couple of minutes for any further questions.